talk about the likelihood of confusion factors that are relevant to establishing whether or not there is trademark infringement. So, as you know, there are many different factors and actually different circuits that have differently worded tests. However, those factors basically all are assessing the same thing. And even though worded differently, they're functionally equivalent. They're all intended to get to the overall conclusion of whether consumers are likely confused. You don't need a majority of the factors to establish that there is infringement, and you may not even have information on all of them. These are just factors that are laid out as possibly existing to help you evaluate. Now, these images are intended to highlight some of the key confusion factors. Number one is strength of the plaintiff's mark. That's what the pi symbol is to remind you of. You are not looking at the defendant's mark at all. The strength of the plaintiff's mark is important both regards to its market strength and also its trademark strength. How distinctive is it? So for this, it's not enough that the mark is registered. You have to say, is the mark, say, suggestive versus arbitrary or fanciful, if it's a word mark. Or if it's a trade dress, you have to show why it's really unique, i.e. more distinctive. You should not be evaluating the comparative strength of plaintiff and defendant's mark. The only focus is the plaintiff's strength, market and trademark. Okay. So the next thing you want to consider is the relatedness of the goods. That's what the little diagrams on the right are supposed to indicate. That's an abstract image, but the general idea, if they're not the same goods, are they things that are sort of similar, like wine and cheese are considered complementary goods. Another big issue is the similarity of marks in terms of sight, sound, and meaning. The more similar they are, the more likely there's to be confusion, especially if it's a strong mark. Now, there are some additional factors that may or may not always come into play. So one could be expansion or bridging of the gap. So somebody's not currently making the same product, but they're likely to get into that area. Or maybe they're not in the same geographic area, or they could be. Another one could be marketing channels. They're not currently both in retail stores. One's in a private boutique store, but maybe they will be both together. Another is consumer care or sophistication. Basically, that means the more expensive a good is, the less likely there will be confusion because consumers tend to spend more time evaluating before buying, say, expensive car. Also, there could potentially be actual confusion by some consumers, but this very, very rarely exists because usually the trademark owner will file a lawsuit before use or shortly after use such that there is not confusion. Also, there could be bad faith intent, but again, this does not always exist. And just because you didn't do a trademark search doesn't mean it's bad faith intent. So that's a big picture overview. Hopefully that helps.